I am IZATI binti HANAFI with metric number 066125.
Assalamualaikum. My name is NISRIINA binti HASANUDDIN and my matrix number is 068787.
Hi, my name is WAHIDA and my matrix number is 066176.
My name is ATHIRAH binti AHMAD HAZIM with metric number 066542.
Introduction to the injunction. Injunction, or similarly known as the writ of prohibition under common law, is one of the equitable remedies provided in equity. It is governed generally under Section 50 and 51 of Specific Relief Act 1950. Injunction is a type of preventive and injunctive relief. In order to give effect to the legal rights of the claimant, injunction is an order made by court either to restrain a party from performing a particular act or to require an act or performance from the party himself. It is also an order given to restrain the harmful act, continuance, or repetitions of certain conduct which infringes or violates the rights of the claimant. Injunction is classified or divided based on two ways. The first one is its effect or purpose of such injunction, and the second one is granting time or duration. For the effect and purpose, it is further divided into a prohibitory and mandatory injunction. So what is a prohibitory injunction? This injunction prohibits a party from doing something, while in contrast, the other injunction, which is the mandatory injunction, will require a party to perform a positive act to the party in which the legal rights were infringed. Meanwhile, the granting time or durations of the second division is divided into interlocutory or interim and perpetual. So the involvement of time, as stated here, is governed under Section 51 of Specific Relief Act 1950. And interlocutory, or also known as a temporary or interim injunction, is a temporary order for the party to maintain the status quo until the date of the trial. In contrast to it, the perpetual or permanent injunction is the final order of the court after the decree was made at the end of the trial, and this injunction would give the claimants what they wanted. However, an injunction, whether it's temporary or perpetual, it will be granted at the will of the court as governed under Section 50 of Specific Relief Act, which means that the court has the power and authority to whether to grant the injunction or not. It's at the mercy of the court. So the modern type of injunctions includes 4 types of injunction, which are Mareva, Antenkila, Timet, and Eribon type. Under equity, Timet is a type of injunction granted based on the existence of a threat to the plaintiff's rights which may be infringed. It may have been granted before some alleged infringement of the plaintiff's right occurred. Moreover, this injunction may either be granted for 4 conditions, which are interlocutory and prohibitory, interlocutory and mandatory, perpetual and prohibitory, or perpetual and mandatory. So in the present time, this injunction is available on all matters by virtue of legislation implementing the judicial system. As Timet injunction is a matter of interim or interlocutory injunction, time is of the essence for it to be successfully granted, which means that the time is regarded as a necessary or essential part for the court to take in consideration to grant this injunction. However, the court may also refuse or reject the petition governed under Section 54 of Specific Relief Act 1950. The court has the power to either refuse or grant this injunction. Now, there are 2 categories of circumstances available in this Timet injunction. Firstly, the claimant would assert that although the defendant had yet to inflict any harm or damage, he is threatening and intends to carry out action that, if done, would cause irreparable harm to him or his property, which is the claimant's property, or to his own body. Secondly, the kind of litigation when the claimant has received total compensation for the harm he suffered in both law and equity prior to the claim, but then he still claims that the defendant's prior activities may give rise to prospective causes of action by the time he files the injunction claimant for the Timet. So now, these 2 circumstances would give rise to a possible successful claim of Timet injunction, as we look as per the case of Tim Trumpel against Yap Kent or Yap Shin Tian. The differences between Timet injunction to other types of injunction would include a strong probability case, proof of imminent danger, and proof of apprehended damage. If harm will be very substantial. So the principles of this Timet injunction can be seen in all the cases of Redland Briggs Limited against Morris, Attorney General against Manchester Corporation, and Attorney General against Corporations of Nottingham. So these three are the oldest cases to be referred.
The nature and elements of key Timet injunctions that need to be proven are almost similar to those required for other types of injunctions. They include two elements. First, proof of imminent danger, and second, proof of substantial apprehended damage. However, the claimant must also show that they have a strong case on the merits of the underlying claim and that they have a good chance of success if the matter goes to trial. If this type of precaution is not taken seriously, it may cause further trouble and be costly for the defendant, although it might not involve the undoing of what was done.
Is the element of proof of imminent danger a reasonable possibility that there is a danger irreparable to the party must be established to the court. The court will decide whether to grant the injunction or not based on the balance of harm and the public interest. Further understanding regarding this element can be seen in the case of Syarikat Faizan Sidang Bahad and another against Faiz Shah Sidang Bahad and another suit. In this case, High Court grants the defendant a perpetual coercive injunction or by other means a permanent injunction. This avoids multiple judicial proceedings and strengthens finality in all parties' lawsuits. It is also because if the other party uses the same or similar trademark to the plaintiff will feel the imminent danger which their company assets. In Maghrib debt istiqraz and others against NKVs and others, the risk can be seen when the court injunction was granted to the plaintiff to restrain the defendant and or the agent or servant from commencing any further proceedings about the status of my PPP, political party, and or seeking criminal relief to those praying for in the KLCR and or Penambahan originating summons or the Arista originating summons. The plaintiff will suffer irreparable harm if the defendant proceeds to initiate criminal proceedings in the High Court to seek relief. Other than that, you can see in the case Pacific and Orient Insurance Corporation against Muhammad Hafizi Bahari and another, where the plaintiff was entitled to quantum injunction due to defendant's threatened execution or winding up procedures. According to the case of PPES Resort Sidang Bahad against Kerontop Sidang Bahad and Badland Bricks Limited against Morris and another, it will create irreparable harm to the plaintiff. Furthermore, in Genting Highland Bahad and other against GM Air Support Sidang Bahad and other, the quantum injunction was granted as the plaintiff succeed in establishing that there is real and imminent danger of loss. It is so that the plaintiff can preserve his status quo and prevent himself from harm by the defendant's action.
As my fellow group members have discussed before, key Timet injunction require the plaintiff to demonstrate that the danger or substantial apprehended damage is inevitable or imminent. So what is substantial damage? It is where the damages causes actual economic loss for which substantial compensation is awarded. Substantial damage is being assessed or determined by courts with consideration of the plaintiff's actual loss. The discussion of this particular second element and nature needed to be proved will be through the decided cases. Allow me to present the first case, which is London Borough of Islington versus Elliott and another, where the claimant sought an injunction requiring Islington to take action to prevent nuisance from encroaching tree roots where no physical damage had yet occurred. The case provides valuable guidance on the court's approach to key Timet injunctions intended to prevent future threatened wrongful acts or harm, as well as compliance with pre-action protocols and costs. Moreover, in the case of Merck Sharp Domer and Bristol Myers versus Teva Parma BV, Bristol Myers or BMS sought injunctive relief alleging that Teva's action in obtaining marketing authorization for Europe at an unusually early stage during the patent term, as well as its refusal to provide details about its intentions regarding the launch of generic efavirenz in the UK, indicated an intent to infringe the patent and SPC. Teva countered this claim, and it should be dismissed because it was based on whether Teva's action constitute a threat to infringe rather than the validity of the patent. the judge thought BMS had reasonable grounds for seeking injunctive relief, referring to the fact that Teva went to the trouble of obtaining marketing authorization for efavirenz. In the judge's opinion, provided a solid stone insinuation that Teva intended to sell efavirenz at some point. Now, in the case of Clark versus Series 5 Software Limited, it is the case where the claimant company sought an interim injunction to prevent ex-employees from using commercial information and company equipment. The High Court denied the application on the grounds that while the injunction sought could effectively deprive the defendants of their means of earning a living, the claimant's assertion lacked credibility of substantial and immediate damage, hence unsubstantiated. Lastly, in Azman bin Muhammad Yusuf versus Vasaga Sendirian Berhad, the court considered the severity and impact of the nuisance and found that damages were insufficient to compensate for their mental anguish and agony while waiting for the trial, and ordered an injunction that the defendant be restrained from inciting nuisance to the plaintiff until the trial is concluded. So, from the discussion, we can see that choosing whether to grant temporary injunctive relief is up to the discretion of the court, in which the court balances the irreparability of harm and inadequacy of damages if an injunction were not granted against the damages that were resolved if an injunction was granted.
As a conclusion, a court may impose an injunction known as key Timet to stop the threatened injury or damage from happening. It is frequently requested by a claimant who believes that damage or an injury may happen in the future but has not yet happened. Key Timet injunctions, which are often granted on interim basis until the case may be considered in its whole at the later date of trial, are a temporary measure in favour of the claimant. That's all from us. Thank you.